Today's courtroom is a storm of chaos and consequences. Meet Sadie Ivan Murphy, a woman once offered a second chance through probation and treatment. But things took a dark turn behind bars. Violent incidents, self-harm, and a judge caught between compassion and control. As tensions rise, one question hangs in the air. Can rehabilitation save someone spiraling out of control? Or has the line already been crossed? Stay tuned, because this one ends with a hard reality check from the bench.
In the jail, violent ones. So we have pulled that offer.
What's the deal on that? We had Dr. Rapon's report. She ought to be okay.
Yeah, we had safety on MPRP and 10 years deferred, but it's come to light that apparently she's been having some issues
What?
with the jail. I didn't know.
It's on my watch. What is it?
found out-
What issues are we talking
I just
about?
found out today. I didn't know about that.
Your Honor, based on the incident reports that we're able to see through Odyssey,
Yeah.
I've printed some. They're very difficult to transfer into other than snipping and clipping. But we have reports, a stack of them dating back to where
So when?
her first incarceration in last July of 2024, since she's been in custody.
Well, I want to know what happened since September 18th of 24. That's when Dr. Rapon evaluated the defendant and we.
I printed one from July 21st of 24, which was an information report. In
From when? What's that?
July 21st of 24, we go to December 21st of 24, December 27th of 24, as recent as March 9th of 2025, March 2nd, 2025, and February, I believe this was February the 20th of 2025.
Okay.
Incidents that include her attempting to take her own life, as recent as, I believe, yesterday. She had asked to speak to a mental health provider.
This is a deeply alarming detail. Murphy reportedly tells staff she might harm someone and is found with a rope twisted around her hands. In any courtroom, this signals two major concerns. One, her mental health is in serious crisis, and two, she poses a threat to others. Judges must walk a tightrope here, balancing safety with compassion. But when violence becomes repetitive, sympathy starts to fade. It's tragic, because what started as a plea for treatment is turning into a case about danger and control.
37 days.
237 days, Your Honor, and Ms. Murphy is exhibiting continued aggression and violence and lack of respect for authority. And
Okay.
I do understand that Ms. Murphy has a need for substance abuse treatment. That was the reason for the initial request for safety, but the behavior she exhibits in custody right now at a safety unit would be totally unacceptable. It's unacceptable in our facility.
Of course.
And the danger that we're putting other
All right. Okay.
clients in.
Well, I looked at Dr. Rapon's report, which I trust, and he determines that she is competent. So the choices people make are the choices they have to live by. And if you make bad choices, then you're going to be punished. If you make good choices, you're rewarded. It's the way it works. It's that simple. And that works in this court as well as in the free room. And we can't have assaultive behavior anywhere, much less in the jail where we've got a lot of people that the authorities have to maintain control over. The important thing that you must remember is that you're looking at a third-degree felony, and it's on my watch, and it's my decision on a motion to revoke probation. At the end of the day, it's going to be mine. And then you got this new case of another third-degree felony, and both of these are assaults. And this was this new case was filed. Just August 13th and of 24. So you had been, I had placed you on probation. 2 months later, you're assaulting another public servant. And obviously that is not something we're going to tolerate. Shame on you the first time. Shame on me the second time if I don't do the right thing on my watch. We'll just have a motion to revoke probation hearing. We'll set this first in just a couple of weeks.
Okay.
I mean, it's going to be the allegations. Well, we've got 6 of them, right? No, 2. Yeah, 6. And they are administrative. And then 1 is the new case here. And the court will be the arbiter on this one. And I need this back in the file, Dr. Rapon's report. All right, y'all be ready.
Thank you,
and be prepared. So I intend to resolve this in 2 weeks in one direction or another. Okay. Thanks. Yes. All right. Next is Marvin. What's this?
We reached a deal in lieu of, we have a new deal now.
A what?
We got a new deal.
You said a new deal.
New deal.
That's 2 news.
Two new deals.
That's too much news.
That's too much, huh? Yeah, we were able to work it out this morning.
A few minutes ago, there were no deal based upon her conduct. Now what?
What happened was the old deal was deferred in safe P. Now the new deal that we reached is 5 years TDCJ, which is going to be pen time. That's the new deal.
On what? Both cases?
In both cases to run concurrent. And that way we'll dispose of both cases today. And like I understand, the state is no longer going to do the probation deal. So we reached an agreement for the pen time deal.
Is that what you want?
Yes, sir. And that'll finalize it.
Oh, let's do this in numerical sequence. Okay. The first one is cause number 24-CR1187, the motion to revoke probation, a first amended motion to revoke probation. And this is the state of Texas versus Sadie Yvonne Murphy. That is you. You have to speak out so she can hear. Okay. And Mr. Adams is representing you, and the state's attorney is here. There's a first amended motion to revoke unadjudicated probation. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir.
And raise your right hand, ma'am. Do you solemnly swear or affirm any statement you make during these hearings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hands, perfect. In summary, this first amended motion to revoke unadjudicated probation states that on June 10th, 2024, in this court, that you were placed on 10 years deferred or unadjudicated probation for the 3rd-degree felony of assault of a public servant. Do you understand what you're charged with here?
Yes.
Allegation 6
Yes, Your Honor.
alleges what's in this new indictment, 24-CR1984, and we will use this as the basis on this motion to revoke probation in this case. Number 6 states that you violated your deferred or probation order by committing the offense of assault of a public servant on or about August 13th, 2024 in Jefferson County, Texas. Do you understand fully what you're charged with in this allegation?
Yes, sir.
Is this allegation true or untrue?
True.
Are you pleading true voluntarily, knowingly, intelligently, and after discussions with your attorney?
Yes, sir.
You understand that a knowing and voluntary plea of true to one or more violations of probation, that would be enough to grant the motion to revoke probation. Your probation can be revoked And you could be sentenced to no less than 2 nor more than 10 years confinement in prison since you're on probation for a third-degree felony. No.
This is a deeply alarming detail. Murphy reportedly tells staff she might harm someone and is found with a rope twisted around her hands. In any courtroom, this signals two major concerns. 1, her mental health is in serious crisis, and 2, she poses a threat to others. Judges must walk a tightrope here, balancing safety with compassion. But when violence becomes repetitive, sympathy starts to fade. It's tragic, because what started as a plea for treatment is turning into a case about danger and control.
Or 1984. Is all of that true?
Yes, sir.
These sentences would run concurrently, correct? If I follow this, you have no right of appeal. You understand?
Yes, sir.
Did you sign that document? Understand it? Discuss it with your attorney? Is everything true and correct?
Yes.
States Exhibit 1 tendered into evidence?
No objection.
Without objection admitted? In summary, this states that if I follow this agreement, you will have no right of appeal on this motion to revoke probation disposition.
Yes, sir.
Okay, then it is made a part of the record. I'm going to follow this agreement and find there is sufficient evidence supporting this motion, first admitted motion to revoke unadjudicated probation to grant it by a preponderance of the evidence or greater. Allegation 6 is proven true as the defendant has knowingly and voluntarily pleaded true to that allegation of committing the new offense of assault on a public servant, which was indicted and represented in the new cause number 24 CR 1984 in this court. Thus, your deferred or unadjudicated probation is hereby revoked, as I find you have committed this violation, proving by a preponderance of the evidence or greater. Earlier in this case, you had pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea at that time through States Exhibit 1 admitted in the hearing to find you guilty beyond a reasonable doubt. Your deferred or unadjudicated probation is hereby revoked. I now find you guilty beyond a reasonable doubt of this offense in 1187, again, a third-degree felony of assault on a public servant. And finding you guilty beyond a reasonable doubt, I follow this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. 24 CR 1984 is now called. Does the defendant waive a formal reading of this? And we proceed in summary here.
Yes.
In summary, this indictment alleges that was handed up on September of last year, that on or about August 13th, 2024 in Jefferson County, Texas, you committed the third-degree felony of assault on a public servant by assaulting someone who was a correctional facility employee at the jail in Jefferson County, Texas. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement's been reached in this case as well. You would be pleading guilty, found guilty, sentenced to 5 years in prison to run concurrently with the preceding case that we revoked you on. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand that?
Yes.
How do you plead to this, guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily, that is on your own free will, and because you are indeed guilty of what this alleges?
Yes, sir.
I show you what's marked as States Exhibit 1 in this case. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct?
Yes.
States Exhibit 1 is tendered into evidence
No objection.
without objection admitted. And this states as well that you were mentally competent to enter your guilty plea. And we all know from Dr. Capon's report that you've been analyzed and found competent, and there's no indication the defendant is incompetent,
No.
correct? And you are totally satisfied with the representation provided by your attorney. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You understand what you're charged with. The indictment's been read to you. You've read it. You were guilty of that crime and any lesser included offenses. So help you God. State's Exhibit 1. That is part of the record for all purposes without objection. Pre-sentence report is when?
Yes, sir.
I'm going to follow this agreement and find, if nothing further, that you, ma'am, are pleading guilty here voluntarily, mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I'm doing that. I'm going to find you guilty beyond a reasonable doubt, as agreed upon by all the parties and as you have elicited in your plea of guilty. And I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. These two sentences shall run concurrently. Do you understand what has happened today?
Yes, sir.
Looks like what we have is an anger management problem that is something we all deal with. We all wrestle with. It's not like you're odd, you're normal, and we all get upset and lose our composure from time to time. It's normal. But you have to be able to think ahead on this and go, look, I'm going to get upset, but I've got to rationalize this early and have a plan. When I catch myself doing this, I've got to do something to talk to myself so that I am alert that, hey, this will have consequences and I could be punished severely. Is it worth it for a silly hissy fit that doesn't really get you anywhere? And, you know, we all struggle sometimes with losing composure, but you have to grab a hold of yourself and think, how much do I have to lose and how much do I have to gain? Generally, is not anything to gain and everything to lose. And that's the way it is for everyone. Kind of think about that. Plan ahead because it'll happen again. And you just don't want to go to prison over something that's just losing your composure over. And I know it's frustrating. You go, this is just, I don't like this. This isn't fair. But we all have to deal with it. And sometimes you have to shrug it off and move on.
This is the moment everything changes. By pleading true to the violation, Murphy effectively admits guilt. No trial, no excuses. That's a legal surrender. It's rare to see a defendant plead true when the consequences are this steep. But it shows she either accepts her fate or realizes she's out of options. Under Texas law, that one plea allows the judge to revoke her probation and impose up to 10 years. The fact that the state agreed to 5 concurrent years means she's getting some mercy. But make no mistake, the judge is sending a message. Welcome back to Courtroom Chronicles, and buckle up, because today's case is a wild one. We're diving into the chaotic hearing of Marcus Miles, a man with a long rap sheet and an even longer attitude problem. From failed drug tests to outbursts in court, this one spirals fast, and Judge Stevens isn't playing around. By the end, things explode when a simple interruption leads to a massive $50,000 bond. Stay tuned. This hearing is pure courtroom tension.
Today?
Your Honor, we're asking for a 3-week reset at least in order to get this case re-indicted with the correct officer's name.
Okay. All right. Any objection at all? Did you say 3 weeks?
Yes, at least.
Okay. All right. Done. Just want to make sure, get a resetting and then have a reset seat over there.
Well, I don't think he's going to be able to get a reset because it hasn't been indicted yet.
What's the reset to get, come here?
Okay. I'm just making sure,
We
Judge.
can reset this case and then when
Okay.
a new case comes, we'll
So
decide.
I was just making sure because I know that if it's going to be a new cause, I just want to make sure we're all in the same boat. So
We'll move it with them.
Mm-hmm.
I trust them. Okay.
Me too.
They're going to get you a reset so the next day to be here.
And then just have a seat right over there before you leave. I want to test you to make sure all is well.
No, no, right here. Yeah, you're good. You're
Get
good.
a resetting from that lady.
And then you're going to need to sit over here.
Right there.
Say that you.
And sir, this is from a fight. This right here, you see this? I got in a fight. No fight.
What does that have to do with
That's what I
what
was,
you're charged with?
I was trying to tell you.
Oh, okay. Wait, I got Sagar Patel is reset, right?
Correct.
Sagar?
Yes, sir.
That's right, Brent. Huh? Patel.
Well, my understanding is that's
Well, I mean, it says reset. He doesn't need to be here, so you just have a seat in the box. Thanks. Michael Pete. Michael Pete. Three take three.
You trying to dilute it, yeah.
Sit down. Sit down.
Now what?
He's asking him, could I get a little? He's being the officer, man, or,
You don't have,
And here's where Marcus starts unraveling, interrupting, questioning orders, and testing the court's patience, literally. The judge orders a drug test, but Marcus argues and refuses. That's a major red flag. Refusing a court-ordered test is automatic grounds for bond revocation. The tension here isn't just about drugs, it's about defiance. What do you think? Should judges show patience in cases like this? Or is tough enforcement the only way to keep order?
Going to be revoked for refusing to do that. Well, no matter what the result is, your bond is going to be revoked for refusing a court order. Do you understand? Now, we're going to wait all day if we have to, but if it gets to the dark, it's going to get revoked.
I'll get that, man.
Go do it. Go give a specimen.
There is another issue. He
Yeah.
asked
No, I did.
the gentleman back here just to put water in the test. I guess he wasn't able to actually urinate in it.
I didn't tell you.
So he's trying to
That,
falsificate.
and that man, look, that man trying to see, look, sir, I told him to give me some water. He's sitting up there getting mad at me because I can't pee in the cup. He getting mad at me because I can't pee. That's what I'm saying. He getting mad at me because I can't pee.
He said he's gonna give you another chance.
All right, that's all.
Go on in there.
And you know, I've been coming up there. I ain't been running for nobody.
Not a debate. It's an order for you to give the specimen, sir. Thank you.
Yeah, just give it one more.
Who is your lawyer?
Brent.
You Brent, you okay. All right, and Marcus Miles, 24 CR, don't interrupt. It just, you come right out and you're rude. You've been doing all the talking. That's all I hear. Just you back there for the last 30, 45 minutes doing all the talking, but you don't act. You're not acting in a responsible way. In 24 CR 1680, you were indicted by the grand jury for evading arrest or detention. And that is a state jail felony. And you have 3 prior convictions in 09 and 14 and 2021 in felony courts as well as county courts at law for evading arrest and detention. I mean, you would think after the first one, you'd understand what the rules are and how.
This is where the emotional meltdown begins. The judge's patience is clearly thinning. Marcus interrupts again and again, trying to explain himself mid-sentence. Judges value respect and silence in court, because every interruption undermines authority. It's not about ego, it's about control and procedure. And when Marcus casually calls another judge by her first name, that's the breaking point. In a courtroom, that's like throwing gasoline on a fire.
You to provide a urine test, which you have failed to do. His bond is what?
$6,500.
Okay. Your bond is increased to $15,000. Plus, you must have a drug patch as a condition of bond if you post the bond. Plus, you have to have a GPS device so I know where you are at all times. You want me to add some more? Every time you make a crass remark, it's another reason for me to lodge another condition of bond because you're just asking for it. You're giving me reasons why we need to be protected, the community, from your ridiculousness. Don't you think 1, 2, 3, 4, 5 convictions, felony convictions is enough, and a 6th one on the way here with this one? It's time you started following the rules, Mr. Miles, like we all have to. Anyway, that's, I want a GPS device. You're going to be on home confinement. You can leave home if you do all of this, if you're able to get all of these conditions done. You have to stay home, but you can go to and from your lawyer, to and from food, to and from medical care, and to and from church. But you have to go in the most direct route possible, and you have to work with the company that's working with the GPS so that they know what those routes are. And then what are we going to do next? What's the next event?
The,
Trial?
yeah, well, state, they have to re-indict this one.
That's correct, Judge. This is the one where the indictment was wrong.
Okay, well, I'm just gonna put it on trial and we'll set it for trial. Let's move forward for that. And if it gets disposed of otherwise, then great. If not, let's fast track this, okay? Those are the conditions. And again, here, the standard bond conditions, sir, as you know, and this is why you're in the problem, is that everyone on bond is subject to being tested for drugs and alcohol at any time as directed by the court. That's standard bond condition number 2 of the criminal courts. Both of us, Judge West and I, have both signed these orders since 2022. Everybody knows what they are. You fail to provide these specimens as ordered, then that is why your bond gets revoked. All right, anything else? That is all. We're taking, it's taken into custody. Thank you. Okay, let's now, Brent, let's get together on that plea agreement y'all got on Mr. Gothe, so we can move on to our next part of our life. We have you back here, Mr. Miles, in cause number 24 CR 1680. As you know, I had ordered you to provide a urine specimen, which you failed to do. And the your bond, because it is based upon requirements, including, you know what? And if there was a felony for interrupting, you'd be guilty of that too. You can't help yourself. You got to be in control. You can't follow the rules of just common decency. So one of the conditions of bond is you must provide specimens if ordered, and the court ordered you to do that. You failed. Your bond was increased to $15,000. Plus, I've ordered you a drug patch because of your criminal history with illegal possessions of drugs, a GPS, and house arrest. I wanted to make sure you understood that house arrest is you can leave for those necessities, and I think I touched base with them. All medical necessities is a necessity. You need to have medical treatment. You can leave your house to and from the most direct route, food, to your attorney's office. This is all in the most direct route, and also a church. Those are all important if you need those. And again, you must, if you do get a GPS device, the people with the GPS need to know exactly where when you're going to go. You have to alert them ahead of time, and you have to tell them exactly where and in what route you're going to be taking. Do you understand that, sir?
Yes, sir.
One other thing. Apparently, the court next door is trying to select a jury, which apparently you and the other guys in there have interrupted. She came in to talk to y'all about it. Yeah, you're apologizing now, but you interrupted those court proceedings. Plus, you referred to her in a derogatory fashion.
I didn't know her. I didn't know her name.
No, you said you referred to her as Raquel.
Nah,
You just
sir, I don't
you
know.
can't help yourself but interrupt, can you? Let me speak, and you'll get a chance to be heard, sir. You don't. You have to speak to people with respect. live honestly, harm no one, give each person respect. Those are the basic principles all of us for living together on this planet should respect and honor and practice. You, however, with your rich criminal history, have refused to follow the rules, and now you're showing disrespect to an elected official, a public servant. I know what you did. I know what you did. That $15,000, it's $50,000. It's 50,000. You have to show respect. You can't interrupt proceedings in this courthouse. We're trying to take care of a problem, the 22nd largest county with the 16th highest crime rate. We have, which includes you in the crime rate. We're doing our best to run as fast as we can. We don't need people who act like you, disrespectful, to continue to interfere with the proceedings. Do you understand everything I've said? I've spoken in English. Anything you want to say?
Yes, sir.
Go ahead.
About that, I was having a word with one of the little fellows, and I was trying to ask him what was going on, what and she kind of like was walking by, and I was like, she was like, can y'all keep it down in there? And I'm like,
you were interrupting the
no,
proceedings.
I didn't know that, boss.
We have courts on both sides. You have a rich history of.
My born has.
You know what? Let me just get this point out. You were convicted in this court. You have been convicted in the 252nd District Court next door. You know what these courts were, you know how close they are to the holding cells. And you know you can interfere with them. Don't act like you're amazed and I can't believe it's not butter. You know when you're acting loud and boisterous, you're going to interfere, and they're trying to pick a jury over there. And nonetheless, we're in business every day. But to refer to her in a derogatory fashion by calling her by her first name and you said some other things, but I'm just referring to that. She has earned respect. We've all earned respect, and we're going to respect you. But sir, you're not handling your problems responsibly, and your bond for interfering with the court proceedings next door goes up to $50,000. I can move it up some more if you want to keep violating conditions of bond or acting rudely, but let's just stop with this and learn our lesson and move forward. All right? Anything else?
Yes.
You've got a problem with this case. You need to deal with Mr. Turk in a responsible way. Don't be rude to him.
Yes, sir.
But you're in a big mess here.
My bond has just been revoked, sir, and you got to look at how kind of like was lashing out in the cell.
That's no excuse to interfere with the court proceedings.
Sir,
you can feel disappointed all day long, but you don't interfere with the court proceedings. Do you understand?
I apologize about this.
Well, you can't undo them. You can't do it when he has to.
I didn't know that was her.
You know where the courts are. You've been in both courts.
No.
Sir, you got a conviction in next door and you got a conviction here. Don't tell me that this is foreign to you. You know how this works.
Sir.
You're in holding cells. You've been in holding cells here in the past. We're just a few feet. Both courts. You know what it is like. You were taken in and out of the holding cell, which is just a few feet from the courts. You know you can interfere with the proceedings by speaking rudely and loudly, and you did it.
I tried to apologize.
Well, try to. You need to act more responsibly and less rudely and show respect to people, everybody.
Just to tell you that I didn't even cuss. I didn't tell her nothing.
You interfered with their.
And that's where the gavel drops on Marcus Miles. A $50,000 bond, GPS tracking, drug patch, and house arrest. All because he couldn't stop talking over the judge. This case is a masterclass in how courtroom respect, or the lack of it, can completely reshape a defendant's future. So, what do you think? Was the judge too harsh, or was it fair given his history and behavior? Let us know in the comments. And if you found this breakdown as wild as we did, hit that like button, share this video, and don't forget to subscribe for more jaw-dropping courtroom moments, only on Courtroom Chronicles. Welcome back to Courtroom Chronicles, where justice isn't just served, it's tested. Today, we're watching a tense sentencing hearing for a man named Mr. Cubic, whose long battle with addiction, recovery, and relapse is about to collide head-on with the court's patience. With 6 prior drunk driving arrests, a lifetime of near-fatal choices, and a defense team fighting for leniency, this case asks one question. How many chances does someone really get before the system says, enough? Stay tuned, because this one takes a shocking turn.
There appears to be a typographical error on a number of cases.
COPS?
Yeah, we would ask that be correct.
All right, so Agent Lesky, is that just a typographical change you can make?
Yes, sir.
In the same form at page 8, under the education section, my client is requesting, so as part of his employment and as part of his work, he obtained a journeyman's card for machine repair, and we would ask that be added under vocational or other training.
Okay, and that's usually a self-reported part of the form. Agent Lesky, can we go ahead and add that under vocational other training?
The Henry Ford education?
The journeyman's card. He says that he acquired a journeyman's card for machine repair. Just make that addition under vocational other training. Mr. Boyd.
Lastly, in the same form, CFJ 284 at page 9, there's reference to treatment at Bright Treatment and Sunrise Center and AA participation at Advanced Treatment Center in 1997 and 98. Those services were actually in 2018. That was following his first interaction with the criminal justice system.
Lesky, were those substance abuse treatment types, were those from self-report or were those documented or? Were they maybe populated from a previous report?
I'm just double checking to make sure, but yes, they did.
They populated from a previous report. What year was the report that they populated from? Do you know?
That right now, I actually have it right in front of me. It was done in 2022.
Okay. All right, but then other than populating from that previous report, are those generally self-reported aspects of the form?
Yes, they are.
And Mr. Kubik is reporting through counsel today that those didn't occur until 2018. What about Mr. Voida? There's 2 of them for Bright Treatment, and one from November 97 and then one from September 98. Do you know when those were? Or?
All I can say is that when I spoke with my client, he said that he didn't engage in any rehabilitative services until after his first encounter with law enforcement in 2018.
Okay, so that would have been the inpatient at Sunrise in 2019.
Well, there may have been in 2018 as well through
on my own,
right.
I went.
Yes,
on my own, I went.
On his own, he went. Sorry, but
that was to what facility? Sunrise Advanced Treatment Center or Bright Treatment?
Brighton.
Is that Bright Treatment? Is that what that is?
In Brighton.
In Brighton.
What's the name of the place?
Brighton. They've changed the name now, but I mean it's the Brighton Rehabilitation Treatment Center.
Mr. Boyd, I mean, I don't know what you want me to do. I mean, I need something specific.
Understood. We'll withdraw the objection to it. We're just trying to correct the. I mean,
okay. I mean, if Mr. Kubik gets some specific information to Agent Lesky documenting something, I'm sure she'd want to make sure that it's accurate. But
understood.
If that's populating from a previous report, apparently there weren't objections, and I don't have any specific information to contradict it. I guess I'll leave it.
We have no other factual additions or corrections and no objections to the scoring of the guidelines.
Okay, and Mr. McLennan, the guidelines are scored advisory at 23 months. Do you have any additions, corrections to the report, or any scoring challenges from the people?
No, Your Honor.
Okay, Mr. Voida, go ahead with anything you want to say on behalf of your client.
Yes, Your Honor. Thank you. As you've mentioned, we've drafted a sentencing memorandum where we outline some reasons for a sentence beneath the guidelines. And let me begin by acknowledging that if we took a snapshot on the date of the incident, we'd be having a very different conversation. You just talked in previous hearing about looking at mitigating factors and aggravating factors. And as of the date of the incident, there were a number of significant aggravating factors. The level of alcohol, his history, the proximity and time from his release from incarceration, a number of things weighing against him. However, we have 1 year and 9 months, going on 2 years really, since then, where there has been nothing but consistent good work and consistent effort by my client to improve his life.
Here comes one of the defense's strongest arguments: medical hardship. Mr. Kubik's attorney emphasizes his COPD, anxiety, and recurring hospitalizations, painting a picture of a man too fragile for jail. In legal strategy, This is called a mitigation argument, and it's meant to humanize the defendant. But remember, sympathy alone doesn't erase public safety risks. The question is, will the judge see this as genuine vulnerability or a convenient excuse?
To change his life. Our sentencing memo talks about two different categories of issues here, and I want to mention both of them, even though I know you've reviewed the memorandum. The first is on the medical side. My client suffers from COPD and a number of other serious medical issues. The list of drugs that he's prescribed to use on a daily basis is 1-2 pages long. It's a lot of meds for a lot of purposes. He takes anxiety medications. He uses a nebulizer twice a day for 10 to 15 minutes per day in order to treat that COPD issue. My client advises, and we've provided at least some evidence of this, that he's been hospitalized in 2024. That was, according to my client, the 7th time since 2017. The 2024 incident involved my client having a serious respiratory episode, wherein he was using his nebulizer. It didn't work. He used the emergency inhaler that he carries with him at all times, and it didn't work. And essentially on his last gasp, he called 911 and asked for help. Repeated his address 3 times. By the time they arrived, his heart had stopped. They were able to revive him. The next thing he knew, he was in the hospital. And so these are not simply minor problems, and they're not problems that come up every so often. He has an everyday medical issue that would be difficult to address in a jail setting. But more important than that, and several hearings ago, I listened carefully as Your Honor was going through a driver's license appeal. And you mentioned that there are too few success stories in a supervision setting. Well, my client's been on bond for 1 year and 9 months, and he is a success story in that regard. During that time, his use of alcohol has been monitored the entire time, first through SoberLink, and then through a Scram device since I think it was September or October of last year. And there have been no violations on the Scram and no found violations, although there are a couple of irregularities noted. No violations found on the SoberLink device. And so here we have a guy who has 1 year and 9 months of sobriety. And yes, that was ordered by the court, but he's still doing the work. In addition to that, something that was not ordered by the court, he has been counseling for 1.5 years with a counselor on a weekly basis. He meets on Thursdays with his counselor and follows through and does the work to address his problems because he knows alcohol is a problem for him and he knows that he can't touch the stuff again. In addition, he's been going to AA twice a week. So he has built this schedule into his life where Mondays and Tuesdays he goes to AA, Thursdays he goes to a meeting with his counselor. And he does all of this without a driver's license. He got here today on a bus, left at 6:30 in the morning. He was here way early for the hearing, knowing that he has an obligation to this court and an obligation to himself to follow through with this. He's relied on friends, he's relied on bus schedules, he's relied on whatever he can to make sure that he follows through with his efforts to maintain his sobriety and to show the court that his actions, through his actions, that he's serious about this, that he can't go back again. Frankly, this is a case that my client belonged in recovery court. It was something that the prosecutor agreed to. We agreed. I think Your Honor would have agreed with it. The only reason he's not in recovery court, I believe, is because the Alpena County Drug Court program folded during the application process. Now, in the past, I've had cases before, Your Honor, where I've asked for less incarceration after a failed effort toward drug court. And Your Honor has correctly reasoned that one of the reasons we reduce sentences in a recovery court situation is because they're under intensive regular screening and probation, where their life is very closely monitored for an extended period of time. And that ordinary probation isn't suited to do that, and isn't necessarily the appropriate venue for that. In those cases I had before, Your Honor, it was a drug situation. It was meth, it was heroin, something along those lines, where testing requires showing up and providing a sample on a regular basis. My client doesn't have those problems. He doesn't have a meth problem or a drug problem. His problem is alcohol. And the lovely thing about this is that we have a way of testing him 100% of the time as to whether he's using alcohol. He's had it on his leg for about a year now.
A year and 9 months.
Well, the scram has been on his leg for a year. Before that, he was using a sober leg. And that's something that the MDOC is capable of handling without any, that's part of what they do normally. And so we would ask, because of the circumstances that we've outlined in here, primarily because he has shown over the last year and 9 months that he is capable of rehabilitation, that the message is working, that he's taking this seriously, that the court depart downward and not order any additional jail time, but that instead you order the extensive probationary terms that are recommended, including a scram device through the MDOC. Judge, I think if you give him this opportunity, see, one of the things we've seen through the history, he's been given jail. It didn't work.
Mr. Kubik finally speaks, and it's emotional. He talks about honesty, recovery, and his commitment to staying sober. But the judge wastes no time cutting to the heart of the matter. Even now, Kubik denies driving drunk in this case. And that's huge, because in sentencing, denial can undercut rehabilitation claims. The court isn't just judging his past actions, it's judging his truthfulness today.
This appears to be working. I don't know why it took him till now to get the message. I don't know why it took him until January of 2024 to understand. But he's shown you over the last year and 9 months that he does understand. Give him a chance to continue showing that to you. And I think he'll earn that opportunity.
Mr. Kubik, is there anything you want to tell me today or no?
I would just like to say that I have in my mind, my recovery path that I'm doing every week. And I see my counselor and everything is working and I need to stay sober. And I just wanted to continue to show that and have that in my life, because
part of recovery is honesty too. And even today, looking in the pre-sentence report, you deny that you were drove after you drank in this case. Am I understanding that right?
yes, I did not drive after that.
You're lying.
No.
Chairman McLennan, any recommendations from the people?
Yes, Your Honor. Defendant 61, he has a prior felony and 6 misdemeanors. This incident happened February 8th of 2024. He's been on bond, as defense stated, for almost coming close to 2 years now, and he has done extremely well on bond. And that was a spirit of the plea why he received such a major benefit with a sentence cap. I would say that these issues with drinking and driving seem to have happened since 2018, and it's been a severe, extreme issue, obviously affecting public safety and defendant destroying his own. In this instance, his blood alcohol level came back at a 0.322. But given all those factors taken together, Your Honor, the people would ask the court to follow the terms of.
All right. I mean, some of what the delay was Mr. Kubik was challenging the legality of the stop. We had a motion hearing and they denied his motion, and then he took, as is his right to do, an interlocutory appeal, which was denied. But I mean, you know, so no, he hasn't drank while he's been on the scram tether. You know, we also need to be careful that we're not setting up an incentive for people to just try to delay every case. You know, this case, that Mr. Kubik has an unusual and remarkable history with drunk driving. 2018, convicted of impaired driving out of Alpena County, violated probation. In December of 2021, he's arrested in Alcona County for drunk driving and possessing a gun while drunk. He fails to attend substance abuse treatment, and he's gets a new drunk driving while he's on that probation, for which he gets 7 months jail. So some of what happened during that probation, just a couple months later in February of 2022, he gets an impaired driving in Iosco County, gets treatment in lieu of jail. November 2022 in Wayne County, an OWI arrest at a 0.29. They just dismiss it. They don't want to deal with it. And also it coincides with the probation violation and the 7-month jail sentence. A month later, or less than a month later, December 9th, 2022, He gets a drunk driving in Aranac County. He gets 1 month jail. Again, that coincides with the 7-month jail probation violation. And then 4 days after he's out of jail, he gets this offense, which is 11 in the morning, somebody calling into the police, say, go get this driver who's all over the road. The police go out there and get him because he's drunk driving. He drove after he drank, and he's lying about it then, and he's lying about it today. And he's a 0.3 or higher. It's your true 5th conviction. It's your 6th drunk driving arrest in 6 years. That doesn't happen very often. I simply cannot abide by a sentence bargain that calls for a downward departure. Mr. Kubik, given your remarkable case, the guidelines do not adequately account for your condensed time period and pattern of drunk driving and the extreme risk that you place to people in the community because of your pattern of behavior. There's an awfully good argument for an upward departure. It would be my intended sentence to commit you to the Michigan Department of Corrections at the top end of the guidelines, not less than 23 months, no more than 5 years, with credit for 3 days previously served, along with some financial assessments. $130 crime victims assessment, $350 court costs, $200 OUIL reimbursement, $68 state costs, and fine $500. Because that exceeds the sentence bargain, Mr. Kubik, you may withdraw your plea if you wish, or accept my sentence. If you want to withdraw the plea, we'll go to trial on the original charges, and I could schedule trial for Thursday, Friday, November 20th and 21st, because the case is so old. I'll give you the very next open date for trial. So we can give you a moment to talk with Mr. Voida about whether you want to withdraw your plea and set it for trial or accept the sentence here today. So we can pass the case if you want, Mr. Voida.
If we could, that would be great, Your Honor.
Okay. All right, let's pass the case and let me know when you want to go.
Judge, can we do Mr. Beck quickly and then I'll meet with him?
Sure. All right, so let's call People v. Theodore Beck. File 2. All right, Mr. Voida, we can recall Mr. Kubik's case. Recalling it's 24-93307FH, the court having announced a sentence that goes beyond the scope of a sentence agreement, and the defendant having a right to withdraw the plea. I gave him some time to consult with his attorney. And Mr. Voida, do you know what your client's option is?
Yes, my client wishes to exercise his right to withdraw the plea at this point.
Okay, very good. The plea will be withdrawn. The case is back into a pretrial posture. Bond will continue on its previous terms, Mr. Kubik. And because of the hearing that intervened, I could even give you a sooner date if you folks wanted. I said I could give you November 20 and 21, Thursday, Friday, or I could even give you as soon as November 6 and 7, Thursday, Friday, because that was where Mr. Goldbeck's trial was and he just entered the plea. Do you have a preference, Mr. Voida?
I'm trying to look at my calendar. Judge, I'm at a conference on the 7th.
Okay, so the 2021 work?
Yes, Your Honor.
Mr. McLennan, is that date good for you?
Yes, Your Honor.
Okay, so Mr. Kubik, I'm not going to schedule any further.
In a rare twist, Mr. Kubik withdraws his plea rather than accept the harsher sentence, putting himself right back on the path to trial. It's a risky move, but maybe the only one left. Cases like this remind us that justice isn't just about punishment. It's about accountability, truth, and timing. How many second chances can one man ask for? You decide. If you found this courtroom moment as shocking as we did, hit that like button, drop your thoughts in the comments, and subscribe for more unbelievable courtroom breakdowns and legal drama. This is Courtroom Chronicles, and the next case might just leave you speechless. Welcome back to Courtroom Chronicles. And today, we've got a stacked docket. 3 defendants, 3 drastically different stories, and 1 judge trying to keep it all under control. First, we've got Mr. Huff, facing probation violations and confusion over new charges. Then, a shocking firearm case that raises serious legal stakes. And just when you think it's over, a final twist. A defendant accused of using a coffee mug as a deadly weapon. Yeah, you heard that right. Grab your seat, because this courtroom's about to heat up fast.
Charged with state jail felonies of criminal mischief, it looks like. You were placed on probation for up to 5 years on December 2nd, and he's already pleaded true.
Yes, we were here once before, Judge, and he was reinstated because there was a significant amount of restitution involved in the cases. And now we're back here again.
They locked me up for trespassing 1. That's why I'm in jail. I went here for a motion to revoke. They locked me up for trespassing.
Do y'all need to amend this motion?
I don't know, Judge. I have not looked at it.
It does need to be amended, Judge. There has not been a first.
Okay, so there's a substantive offense that's come along, allegedly.
There's subsequent allegations. I'm not sure if it's a substantive offense, but.
Well, we put him on probation
in December of 2024.
I'm talking about this allegation true in June. What did I find then? What was my resolvement on this?
You reinstated his probation.
Okay, that's done. What happened subsequent to that?
I don't know. I don't have a new motion to revoke probation filed.
He failed to report, Your Honor. He hasn't reported since continued on probation.
Okay.
It's my understanding.
yeah, I have
that
my-
he absconded.
You're interrupting.
Yes, sir.
Yeah.
But I'm a lawyer too.
Is that just a smart aleck comment
No,
or just you
No, sir.
you're going to step over me
No, sir.
all the time, the whole time?
No, sir.
Shh.
Yes,
You're
sir.
going to get a chance to speak, but the lady has to put down everything as the court reporter. And when two people are speaking, she can't do it. That means somebody gets in trouble. All right. Okay. So the
I'm sorry, Joe.
motion, it sounds like another motion to revoke probation needs to be filed.
And it seems like I have some motions that I need to file as well, Judge.
All right, then
Seems like.
can y'all do that in 2 weeks,
Yes,
everybody? So this man knows what direction he's going to be heading in?
Yes, sir.
The tension here is thick. You can feel the judge's frustration. He's giving Huff another 2 weeks, one final window to figure out his legal direction. But look closely. The judge's tone says it all. He's out of patience. This moment captures what happens in court when second chances start to run out. The courtroom isn't just about punishment, it's about accountability. And Huff's silence, his short replies, they speak volumes. Do you think he'll make it back and turn things around? Or is this delay just the calm before another downfall?
Felony of deadly conduct. And can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about May 5th, 2025, in Jefferson County, Texas, you committed the third-degree felony of deadly conduct by discharging a firearm in the direction of a habitation. Do you understand what you were charged with here, sir?
Yes, sir.
This is a third-degree felony if convicted, which means you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range that's applicable?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. You do well, and it gets closed out early in a third of the time. Another case, 25 CR 1289 will be dismissed. What is that?
It's a misdemeanor on the.
Oh, okay.
Weapon, Judge.
And then you've got this Glock 19 that was involved here. This is going to be forfeited as part of this agreement to the state. Is that your understanding of the agreement?
Yes,
And it
sir.
was a $500 fine also on this deferred or unadjudicated probation. If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead in this case, guilty or not guilty?
Guilt.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Yes.
Yes, sir.
I'll show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct. State's Exhibit 1 tendered into evidence without objection, it's admitted. Among other things, State's Exhibit 1 states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You voted. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. John West is on the YouTube and his tie is showing. This is, do you understand all of this to be true and correct, sir? In State's Exhibit 1. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, Judge.
All right. If nothing further, I'm going to follow this agreement. McCarrick, anything you want to add? All right. If nothing further, I'm going to find you are pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to place you on deferred or unadjudicated probation.
This part right here is fascinating. The judge gives the defendant a deferred probation instead of prison time. A massive lifeline. But let's not miss the fine print. He's also losing his Glock 19 permanently and paying $500 in fines. More importantly, if he fails probation, he could get 10 years behind bars instantly. The judge's warning is crystal clear. Move on with your life and do better. It's rare to see this kind of leniency paired with such a firm tone. What do you think? Fair deal or risky gamble for the state?
Anything else we missed on? You're going to see the probation officer here in just a moment. He will go over all these terms and conditions of probation. Do well. It's in your best interest. You become a better person. And this gets shortened. You don't get a conviction. If you fail, your case could be revoked. You could be found guilty then and sentenced up to 10 years in prison. And then that comes with all kinds of problems. This alleges that you discharged a firearm at or in the direction of a habitation. The use of a firearm in the commission of an offense, if convicted, will affect your parole poorly. It has a negative effect on it. You understand? So move on with your life and do better. Okay. All right. Please see that nice man. We'll see you. Thank you. Do well. Yes, sir. 24 CR 2059 is called. You were Quincy Taylor?
Yes, sir.
Mr. Taylor, and you are charged here with an indictment alleging that you committed the second-degree felony of aggravated assault with a deadly weapon. A second-degree felony, if convicted, carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're facing?
Mm-hmm.
Well, it doesn't end there, because the indictment also includes 2 prior convictions, one in June of 2007 for obstruction or retaliation, a third-degree felony. And this states you were convicted out of the 361st District Court of Brazos County, Texas. After that conviction was final, paragraph 3 in this indictment states you committed the felony of aggravated assault with a deadly weapon, a second-degree felony, and you were finally convicted of that crime in 2017 out of the 85th District Court of Brazos County, Texas. And now, after those 2 are completed, this alleges you committed this offense here in March of last year, a second-degree felony. So, if all of this was true, found true, those prior convictions were true as they are alleged, and then if you're convicted of this, then this is what we call habitual felony status, which means you are looking at, if convicted, no less than 25 years in prison, up to 99 years confinement in prison, or life imprisonment, and up to and a fine up to $10,000 could be assessed. It doesn't end there. The allegation here in this indictment is that you committed this aggravated assault and with a deadly weapon, and the deadly weapon is alleged to have been a mug, I guess a coffee cup kind of thing.
Cool.
And that in the manner of its use and intended use was capable of causing serious bodily injury or death, as you intentionally, knowingly, or recklessly, it is alleged, caused bodily injury to the complainant by striking him in the head with the mug. And the way it is alleged, if this was found true, then whatever sentence you receive, you cannot be released from prison for parole until you serve at least 50% of the time. So if you were sentenced to 30, you'd have to serve 15 before you were released. So these are all serious allegations, and you have to be careful as you work your way through this one. Do you understand?
3 defendants, 3 wildly different outcomes. One might get another shot at probation, another walks free on a deferred deal, and the last faces the fight of his life, possibly decades behind bars for a moment of violence. What we just saw shows how unpredictable courtroom justice can be. It's a balance between mercy, and the weight of the law. So what do you think? Were these rulings fair or too forgiving? Drop your thoughts below. And if you found this courtroom breakdown as intense as we did, make sure to hit that like button, share the video, and subscribe for more real courtroom drama. Every verdict, every twist, every truth revealed right here.